distinguished fellow speakers, collegial bar leaders, dear friends, ladies and gentlemen, good morning. The topic of this session, between principles and enforcement, rethinking soft law and hard law in human rights, encompasses three noun concepts: human rights, soft law, and hard law, and one verb, rethink. To protect human rights was never a piece of cake. Many people sweat, bleed, and even die for it. Initially, the principles for human rights protection were upheld gradually. Then, these principles were enforced through legislation, court decisions, and international treaties. Many lawyers are devoted to these processes. We call it civilization. However, in a civilized and a democratic world that we are proud of, human rights crises are becoming increasingly complex. We say hard law, which means treaties, legislation, judicial decisions, and so on. The hard law delivers enforceability and accountability. But the lawmaking and the treaty processes often lag behind. And the court decisions are notoriously time-consuming. As to soft law, it encompasses guiding principles, policy statements, and multi-stakeholder consensus documents, which move more quickly and allow pilots. However, without institutionalization and follow-up, soft law can become a beautiful but toothless promise. We can have a simple image. In the structure for human rights protection, hard law is like a concrete walls with the binding, clear barriers that are hard to break in, but often slow to be built. On the contrary, soft law is like a scaffolding that is quick to put up and flexible, but can be blown down by the wind without reinforcement. Today, I will share Taiwan's experience. As you may or may not know, Taiwan is not a member of the UN system, and therefore, we cannot formally sign most human rights protection treaties. The constraint is fundamental, but the pathway is not blocked. Taiwan's people and the lawmakers have built a route to institutionalize soft law and gradually harden it. Let me give you an overview of Taiwan's pathway. It involves 5 steps that progress from soft law to institutionalization and ultimately toward hard law. Step 1 involves the domestication of core human rights treaties. Step 2 is to conducting quasi-international reviews at home. Step 3 is establishing standing mechanisms with a clear division of ministerial labor. Step 4 is turning principles into action plans and KPIs. And finally, step 5 involves institutionalization, international dialogue, so that external expectations are reflected in domestic reform. Next, I will take you through each step in more details. Step 1. we bring international standards into the house. Although Taiwan cannot formally accede to UN treaties, we proactively domesticated the core human rights instruments, including ICCPR, International Covenant on Civil and Political Rights, ICESCR, International Covenant on Economic, Social, and Cultural Rights, CEDAW, Convention on the Elimination of All Forms of Discrimination Against Women, CRC, Convention on the Rights of the Child, CRPD, Convention on the Rights of Persons with Disabilities. And we are ongoing efforts toward the Convention Against Torture, CAT. Through legislation or implementation acts, we incorporated procedures that require referring to international interpretations, reviewing and amending inconsistent domestic rules, and submitting national reports, thereby giving these instruments real effect in Taiwan. This is the first key move in hardening soft law. Step 2, we bring review home. Taiwan submits regular national reports, publicly invites international experts to Taiwan for open reviews and a dialogue with the government, and incorporates civil society shadow reports. Reviews conclude observations and recommendations, which ministries are required to address and follow up on. This is not a formal UN procedure, but it delivers transparency, participation, and accountability. Although not under the UN system, we reproduce its functions: scrutiny, debate, conclusions, and follow-up. Step 3, we make the system run on institutions, not personal enthusiasm. In addition to the cabinet-level human rights coordination, the Taiwan government established the National Human Rights Commission on August 1st, 2020. That's 5 years ago. The National Human Rights Commission serves as an independent body for investigations, policy recommendations, and education. It's the hub for interministerial coordination and external engagement. Step 4, we turned principles into assignments. Taiwan grounds abstract principles through thematic action plans. First, the National Human Rights Action Plan sets priorities and concrete measures with the requirements for openness, measurability, and periodic review. Second, the National Action Plan on Business and Human Rights, NAP, based on the UN Guiding Principles on Business and Human Rights, UNGPs, promotes corporate human rights due diligence, grievance mechanisms, and supply chain governance. This is continually updated and strengthened. This step ensures that soft law is not just a slogan, but becomes an annual plan, a ministerial division of labor, and budget items. Step 5, we bring external feedback inside. Since 2018, Taiwan and the European Union have held regular human rights consultations. As you noted, the most recent one was on June 9, 2023, in Brussels. Topics include migrant worker protection, business and human rights, gender equality, and more. These dialogues are more than just an exchange of information. They feed international expectations back to domestic policy updates and legislative reviews, creating a continuous loop. So you see these 5 steps. Why it works? We call it the twin engines of soft law and hard law. Soft law excels at speed, flexibility, and the first mover pilots. For emerging issues such as migrant worker rights, human rights risks in supply chains, and the digital rights, soft law can help initiate action to build consensus and establish practices. Hard law provides stability, predictability, and enforceability. Once society has reached consensus and a clear path, we formalize it in statutes, regulations, and standard operating procedures, thereby securing accountability and continuity. Taiwan's experience is to start with the soft law and anchor it with the hard law. Principles and the dialogue come first. Effective practices are then institutionalized and legalized. These two are not opposite, but twin engines. Finally, I'd like to provide 3 repeatable moves. It's a suggestion. Suggestion 1, we make a review a system, regular review, public sessions, shadow reports, conclusions, and follow-up. All of this help us identify trends, address issues, and foster improvements. Suggestion 2, no KPI performance indicators, no continuity, no budget, no execution. So integrate soft law into the administrative mechanism so that principles become part of daily work. Suggestion 3, mechanisms like the Taiwan-EU consultations are not diplomatic courtesies. They convert external regulatory trends into a domestic reform to-do list. When the concrete cannot be built, we make transparency, participation, review, and follow-up are rock solid. When treaties cannot be signed, we import international standards, write them into law, turn them into procedures, and quantify and quantitate them as KPIs. We hope that Taiwan's experience can send you a message. Between principles and enforcement, we can choose twin engines. Between soft and hard laws, we can choose complementarity. Thank you for your listening. Thanks.
This was Jason Wu, Vice President of Taiwan Bar Association.